So one of the situations that arise and have arisen often is when your I-140 is already approved, 485 has been pending 180 days, and then there is a layoff. So one of our clients has this problem, and he's on the speakerphone with me. I decided to record this for the community because this issue arises a lot, and it becomes quite nerve-wracking if you don't understand what is involved. So once again, I-140 is approved, 485 has been pending 180 days. Remember, it's not required that first I-140 is approved, then 485 is pending 180 days beyond that date. So that's not required. What is required is, let's say we file your I-140 485 today, and after 100 days, your I-140 gets approved. Now we need only 80 more days of the 485 to become 180 days, number one. Number two, you actually do not have to hold the job for 180 days. Even if your I-485, your I-140 is approved, but you haven't held the job for 180 days, you would still be protected as long as you are not questioned and don't have to respond within 180 days. So that's quite a lot of safety. Because even if the government sends you an RFE, unless they send you a notice of intent to revoke, RFE itself gives you almost 87 days in most cases to respond. And all you have to do is produce a letter from an employer that is who's offering you that job, which is same or similar to your green card job. So point number one, 180 days is not counted one after the other. They are counted together. And number two, you don't have to hold the job for 180 days. Now, the question that was asked, first question that was asked was, when applying for new jobs, should I ask for a new H-1B or can I start using my EAD? And the answer is, it is quite safe after 180 days to start using your EAD. And also remember, ideally, I like to have an H-1B in hand because H-1B gives you added protection. So what I want you to do is, if there is a hurry, join the job on EAD, get the H-1B processed anyway. When you start using your EAD, they're not going to give you an H-1B status within the United States, but they'll approve the H-1B. So whenever you have time, you can go get an H-1B visa stamp. And if you re-enter using that stamp, you are back on H-1B. That makes sense?
Yes.
Okay, good. So therefore, go ahead and join with EAD, but keep the future plan of reactivating your H-1B. I think it's a good idea. So your next question was, like H-1B after termination, there is a 60-day rule. Does that rule apply to me also even though I have an EAD? So the rule is the same for H-1B. Let's examine this. So your I-94 is valid for more than 60 days. That means you will get 60 days at least of grace period. If it was valid for 45 days, then you would get 45 days, not 60 days. So you get the lesser of the time remaining on your I-94 or your 60 days, whichever is less, that's what you get. In your case, you get all 60 days. If your H-1B transfer is applied within 60 days, you can start working the moment the H-1B is received by the USCIS. Okay, and they will still give you H-1B status. But if you, let's say 61st day, you haven't found a job, you can start using your EAD, no problem. Make sense?
Yes.
Okay. So the next question was, my wife received her advance parole document and I haven't so far. It's been more than 7 months now. Does it impact my AP processing? No, it does not. No problem. You will get it eventually. Actually, if you look at some of our own history, I've said this before, many times I've gotten green card approval before I got the advance parole. Okay?
Okay.
So the last question you had was, is there a time frame in which I need to get a new job on EAD? No, there isn't. You can, what if you found a job 10 months from now? No problem. The fact that you were out of work is not an issue for the ongoing nature of your green card, as long as by the time the government asks for a confirmation of your job, you have a job offer. Okay? So I just wanted to reach back to you. I just received your email. I wanted to make sure that you don't have any unnecessary anxiety. You're fine. Nothing to worry about. Do you have any follow-up questions?
Yes, Rajiv. So basically, the thing is, in this current market, it is not that easy to get an employer who is ready to sponsor H-1B right away, because the market, you already know, with so many jobs slashing out there. So there will be very less opportunities for the people who are asking for H-1Bs. Maybe I can, in my situation, if EAD is valid, it is easier to get me a job on an EAD rather than H-1B, first thing. Second thing is, asking an employer after getting an EAD and a job that can you apply for my H-1B, that is a part of a negotiation. I need to have it before joining the job or after joining a job. That becomes tricky for me. So I need to weigh my options before joining a job, that if somebody is giving me a job with an H-1B versus somebody who's ready to give me a job with EAD, who should I pick first if I have an option? If I do not have an option, what is your legal advice towards that situation?
Okay, so first of all, you can join using your EAD, okay? But there is one caveat. The government can ask for a confirmation of the permanent job, which is supplement J, if you want to stick with the same employer. But it is possible to work with employer X and have a permanent job offer from employer Y. Okay, so let's say I get a job from IBM that is good for, let's say, it's a 6-month project. I can take that if they are not going to file my supplement J when asked for. Another employer Y, can say, okay, you know what, when you're done with that project, we have a job for you, come on over. They can actually give you a supplement J, a future employer. Okay, what if your green card gets approved before you can even file a supplement J? In that case, I think you are fairly safe. Just document the fact that you're on a same or similar job. So if the government didn't even give you a chance to file a supplement J, don't worry about it. You should be fine. Make sense?
So it is not my responsibility first to go ahead and file supplement J. It is government asking, then I will be filing for supplement J. Is that correct?
That is correct. Now, normally what I do is I like to file supplement J early, because sometimes what the government does is, instead of sending you an RFE, they just send you a notice of intent to revoke, giving you 10 days or 30 days, depending upon what they send you, to respond with a supplement J. So I like to file early, but it's not like you have an immediate urgent need. Get it?
So in case of supplement J, what an employer is supposed to respond back? Like if I join a company, what is expected of that company? Are they have to pay for supplement J?
No.
What is that?
No.
What they have to provide in a supplement J?
No. Supplement J does not have to be paid for by the employer. A supplement, you should go look at it. Supplement J merely confirms the job details, the duties, etc., so that the government can compare whether the jobs are same or similar, your green card job and your current job. Okay. Now, same or similar is a wide field. So let's say you are a software developer and you get a job as a quality analyst, a QA person. Mm-hmm. Could you take that job? Is it same or similar? Yes. What if it is the job as a CTO? Is that same or similar? Yes. What if it is VP delivery of software? Is that same or similar? I would say yes. So even vertical advancement or lateral movement, as long as the prior job is related, would count. I'm giving you a very generic statement. I should assess your jobs. I'm not going to let you file a supplement J without being fairly certain that these jobs will pass muster. But the idea of related is a fairly wide net. I'm not that worried about that.
And there is no geographical location or salary constraint to this particular clause? Like, hey, your salary when you file for H-1B or the green card is this much and your location for PAM was this much. So those have no impacts on the newer job.
Location is not a problem. Okay, but salary can become one of the components that are examined for same or similar job. Let's take an example. Let's say we filed your green card for a job as a lead software developer or as a principal architect. Okay, and the salary promised was $170,000. Now you get a job as a software developer and you're getting $60,000. Now that's a huge reduction in pay. I would have to look at it very carefully to determine whether it is considered to be same or similar. I would still argue it's same or similar. Why? Because it's the same field, the same code. So I think you would still win, but that's one of the factors I look at. Geographical considerations are irrelevant. I'm not worried about that at all. Okay?
Okay.
Now,
And in case of emergency, if there is a travel need, can I be able to travel on advance payroll?
yes,
If I get it?
yes, you can. But don't travel without a job in hand. I always like to have a job in hand when you travel.
Sure.
Okay.
Once I get a job, then I can travel. If I get an AP, I can travel it freely in and out of the country. There is no constraint that I have to get. I'm out of status and I need to get an H-1B again.
No, sir. Advance parole
Okay.
is a full re-entry document. It's pretty unlikely that you would have any problem. I would be fairly safe traveling with it. I want to make one point though. It had come
Okay.
to my mind. Let me make sure I remember that point. Yes, about salary and geographical location. Let's say your green card was filed for San Francisco, $170,000 salary, and then you get a job in a little village in Pennsylvania, where the prevailing wages are actually 60,000. Is that going to be a problem? No. I think we can argue that for the area in which you got the job, lesser salary is appropriate. Okay.
Makes sense.
So therefore, there is a lot of play here, but people who have arrived at that 180-day mark are actually quite safe.
And 180 days from the filing of I-140.
Let me give you that example again. So let's say I file your I-140 and 485 today. Your I-140 gets approved after 100 days.
Okay.
You have only 80 more days to go.
Okay.
Okay. So it's the formulation of the law is I-140 is approved and 485 has been pending 180 days. It is not pending after I-140 day approval. It is pending from the date it was filed.
So pending from the date of filing of I-485?
Yes.
Okay.
Okay.
So Rajiv, I do not have to worry about anymore about H-1B now.
No, you do not. But remember, I told you, whenever you get a chance, you should go ahead and get your H-1B reactivated, just so that you have an added layer of protection. It is not required, but it's a good idea.
Okay.
All right?
Okay. Thank you.
And let Bryant know that we talked so he doesn't make an appointment for us to talk again.
Okay.
All right?
Thank you.
All right. Take care.
Yeah.
Bye-bye.
Thank you, Rajiv.
Anytime.
Bye.